All right, our last mini lecture for today is going to cover the Age Discrimination in Employment Act, or the ADEA. As I mentioned in our last lesson, the Civil Rights Act and Title VII in particular did not account for age discrimination. And essentially, over time, lawmakers realized that we probably needed to put something in place that would cover discrimination based on age. So they developed a separate law, the Age Discrimination and Employment Act, and really it serves to mirror Title VII relative to age discrimination in employment. And I think that will become clear once we start looking at the elements here, that they very much took what was happening with Title VII and the Civil Rights Act and basically duplicated it here, just in reference to age discrimination. So the ADA itself makes it illegal to discriminate against someone based on age. And you can see, just like with Title VII, this is also going to cover a variety of employment practices. So again, hiring, firing, promotions, pay raises, all of those employment concepts would be covered here just like they were in Title VII. Now, an important thing to note about the ADEA is that it applies to employees over the age of 40 only. So if you're 22 and want to file an age discrimination case, you cannot do so. In order to be able to file a case under this law, you have to be over the age of 40. Currently, there's no maximum age limit for protection under the ADEA. So as long as you're over the age of 40, you have the ability to file a claim. Okay, so in order to move forward in an age discrimination case under this law, again, burden of proof is going to fall on the plaintiff. Here, you'll notice that the elements look very, very similar to the elements that we looked at with Title VII case. So first and foremost, they have to be able to show that they're a member of a protected class. And again, here that just means that they are over the age of 40, right? Because we know that in order to be protected under this law, you have to be at least 40 or over. So if they're able to do that, they can move on to the second element, which again looks pretty similar to what we looked at in the Title VII elements. So either they're qualified for the job that they're applying for, or they are successfully performing the job that they have, right? So basically back to this idea of the employee is performing at the level that's expected, or they have the proper qualifications. Third element, again, looking very familiar to what we already looked at, they have to show that they suffered some kind of adverse condition with respect to employment. Again, this could be anything from being fired to not obtaining a position because of age, really any kind of adverse condition that is in respect to employment would suffice here. And then finally, our fourth element, they would have to be able to prove that the employer hired someone outside the protected class or replaced the plaintiff with someone outside the protected class or were otherwise discharged because of age. Okay, so again, basically they would have to show that if some kind of adverse condition occurred to them, that other members outside of their protected class, so people under the age of 40 in this case, were not experiencing similar treatment. Okay, so again, showing that the discrimination was based on age and age alone. This Austin versus Cornell University is a good case or good sample case for us to consider. Here you had two seasonal rangers that worked at the university golf course. If you're not familiar with what a ranger is, a ranger basically goes out on the golf course, makes sure that the golfers are keeping up with pace of play, making sure everyone's behaving and things are moving around nicely. It's not uncommon for older retirees to be in these positions. So anyway, in this case, the two men that were the plaintiffs were 73 and 67. And in 1993, they were not rehired for the season, and they claimed it was because of their age. Basically, they were told that the decision was made based on reorganization that the golf course was making, not poor performance of any kind. So they filed a lawsuit claiming that this discrimination was based on their age, and they were actually successful because they had never received any critical feedback or been disciplined in any way, and the school had, in fact, hired 4 younger, inexperienced people to replace them. So they were able to prove all 4 of those elements in the ADA case. So again, that's just another example of this sort of lawsuit being applied. One thing that we do have to note here with age discrimination cases is that we do have what's known as a bona fide occupational qualification defense, meaning that there are some situations where it would be okay to discriminate on the basis of age, as long as an employer can show that that classification, so that person's age, is actually a detriment to their ability to do their job. Okay, so basically, if age is likely to inhibit someone's ability to perform or limit someone's ability to do their job, then it is okay in those cases for an employer to be discriminatory. So some general examples of this, there are certain qualifications to be an airline pilot, right, in terms of vision. We want the people flying those planes to have really good vision. If someone's age, might lead them to have failing vision, we certainly wouldn't want those people flying an airplane, right? So that's an example of where age might be a detriment to their ability to perform the job. In our field, there are a couple of examples of this. Say someone who's trying to be an athletic trainer or a physical therapist, and they have to be able to work with and maybe help even lift people as they are working through therapy or working through a workout. Those might be situations where age could be a detriment or could inhibit someone's ability to do their job. The same might be true of, say, an event manager position that requires someone to be able to lift, 100 pounds because you have to move bleachers around, or you have to be able to move large pieces of equipment. So that might be another situation where you have a BFOQ, bona fide occupational qualification, that might impact someone's ability to do the job. So basically, there are some circumstances where it is okay to discriminate based on age, but the defendant organization would have to be able to prove that this bona fide occupational qualification exists. And again, this would be a situation where it's really important to include those sorts of pieces of information in a job description, right? So that you can have that evidence that this information was provided up front. Okay. That is all I have on our discrimination law unit. So we will move on next week to look at one more area of discrimination law, and that's the Americans with Disabilities Act. We'll also look at a couple of other laws that led up to the Americans with Disabilities Act, but the ADA will be our primary focus, and we'll look specifically how that law impacts what we do in K&R. And that will really be sort of the bookend to our unit here on discrimination. So make sure that you're completing your module for this week, and when we get together in class, we will apply this content through a case study. Have a good one.